Hey everyone, today we're going to talk about cross-directorships in the context of conflicts of interest. Nowadays, it's very common for directors to hold multiple directorships. It's also known as cross-directorships, especially in groups of companies. For example, he may be director of the holding company and directors of the subsidiaries, and even affiliated companies and companies not even related to the holding company. Being a director of two companies may breach the double employment rule. So it's very important that the director who holds two or more directorships to disclose the fact that he is a director of these two competing companies to the relevant board of directors and to get their consent. This principle is crystallized in Section 1565 of the Companies Act, which provides that where the director's duties conflict with each other, the directors have to disclose it to the different companies. Sometimes the director may risk breaching his duties to one or more companies if he is required to decide and vote on certain matters where the interests of two different companies are not aligned. For example, the entry into a contract, the sale of assets, the acquisition of another company. For example, this company wants to buy this company and the director is a director of both of these companies. So he is conflicted because he has to vote on whether this company is willing to be sold to this company at which price, and for this company he has to act in this company's interest in getting a good price. Whereas he is also on the board of this company, it is in this company's interest to purchase this company at as low a price as possible. So there is a conflict. The company who is entitled to the benefit of the no conflict rule has the right to relax this rule. This principle was espoused in the United Kingdom Court of Appeal case of bolting. So, to use the previous example of this company wanting to buy this company, if this company is valued at 2 million, but this company wants to buy it at 1.5 million, in other words, this company would be sold at an undervalue. So if the director of this company votes in favor of the resolution to sell the company at an undervalue, which would be favoring this company, there is a conflict, but because this company has the benefit of the no conflict rule, if the director of this company discloses the fact, okay, there is a director of this company, and the board and shareholders consent to the director voting in favor of the resolution to sell this company at undervalue, then there are no issues. However, the more common practice is for the defendant to abstain from voting after disclosing his conflict of interest. Sometimes it is not enough to abstain from voting if circumstances require positive action to limit the possible damage which would arise from being directors of two companies where the conflict is so severe that this may even require the director to resign from one or both of the companies to deal with this conflict. This principle was laid out in the Aussie Criminal Court of Appeal case of Fitzsimmons and Crown. So thanks for watching this video on cross directorships.